Hello, everyone. Welcome to another edition of Employment Law Q&A. This is the Wednesday edition. My name is Alex Lucifero. I am the managing partner of Samfiru Tumarkin's Ottawa office, and I'm an employment lawyer. I'm here this afternoon to talk to you and to answer any and all questions related to employment law. If you are having difficulties at work, if you're having issues with your boss or with your employer, if you're let go from your job, if you're dealing with a mandatory vaccination policy at work, if you've been laid off, if your employer is changing the terms of your employment, really when it comes to any issues that you're having with your work, with your job, we are here to answer any and all of those questions and give you the information and give you the advice that you need to resolve your workplace problems. This is a live Q&A, guys. We're live right now. So please feel free to ask your questions. I will make sure to get to all of them. We're live this afternoon till about 1:30 Eastern Standard Time. Again, my name is Alex Lucifero. I'm an employment lawyer with Samfiru Tumarkin LLP. We operate in Canada, in British Columbia, Alberta, and Ontario. Certainly, if you are in those provinces, in those jurisdictions, and are dealing with employment situations, now is the time to get some help and get those questions answered. Right off the bat, I want to give you guys a couple of pieces of contact information. If you're maybe a little too shy, a little too bashful to ask your question right now online, a couple of places you can go. Number one, our website, employmentlawyer.ca. We've got a ton of resources on our website, certainly lots of articles, lots of interviews and video clips where if you're looking for a starting point, if you're looking for some information about your particular situation, you can access those articles and those videos. You can also fill out a form. You can also input your information on our website, answer a couple of questions, and we will get back to you. The other place to contact us is by email. help@employmentlawyer.ca is the email address that you want to contact us at. Give us a brief description of your situation, and I promise you someone will get back to you with respect to your situation. So that's the contact information. To get us started this afternoon, a couple of items I wanted to talk about, a couple of things I'm seeing lately in the news, and particularly with respect to mandatory vaccination issues. I spoke to a gentleman actually just this morning, and this is happening across the country. Guys, lots of employees in lots of different industries are dealing with this issue of mandatory vaccination policies and changes to their work because of it. So I'll explain this gentleman's situation. He's been with a company for 10 years. He was in a sales role. Effectively, the job was a sales position, not healthcare related, not a unionized position. He was simply a sales employee, worked for the same company for 10 years, great performance, no issues. And just about 2 weeks ago, his employer instituted this mandatory vaccination program. Now, the policy was fairly severe. It was basically a black and white. You need to confirm that you are vaccinated by October 10th of 2021, so just a couple of days ago. You need to confirm that you're vaccinated by that date, or we're placing you on an unpaid leave of absence. No other alternatives. So they didn't offer testing or continued mask wearing or any other health and safety protocols as an alternative to that vaccination policy. It was really either be vaccinated or we're sending you home without pay. This gentleman, for whatever personal reasons, didn't want, or actually he confirmed to his employer that he wasn't vaccinated and he wasn't planning to be vaccinated. And lo and behold, come October 10th, he was placed on an unpaid leave of absence. And I spoke to this gentleman just this morning, and here's what I told him. And again, if you're in this kind of situation, guys, desperately you need advice from an employment lawyer. Do not make any decisions. Do not resign your employment. Do not try and fight your employer on this issue without getting that legal advice first. These are very delicate situations when it comes to this mandatory vaccine policy issue. So please make sure you're getting advice in a situation like that. This gentleman was non-unionized in a workplace that was not mandated by the government to institute a vaccination policy. So it's not, again, as if he was working for a long-term care facility, or if he was working for, a hospital, for example, and was required to be vaccinated. This was just a sales job. And so what I told him was this. I told him this kind of policy with no alternatives is unreasonable in your particular workplace. There are lots of things that the employer could have done to continue your employment despite the fact that you're not vaccinated. But instead of implementing those other options, again, maybe testing is a reasonable option, etc. Instead of doing those other things, the employer said, well, if you're not vaccinated, we're sending you home without pay. That is a constructive dismissal in this gentleman's situation. You cannot send an employee home without pay and force them to stay home and not work. That's basically a termination by way of the company's actions rather than by their words. You didn't get a termination letter, you got a suspension letter, but by that very act, the company has terminated this gentleman's employment. So this gentleman's owed severance in his circumstances. It's relatively black and white. This is what we call a without cause termination. This gentleman is 60 years old. He's been with the same company for 10 years in a sales position. He is looking at a year's worth of severance pay based on his age, position, and years of service. So we're going to be assisting this gentleman get his severance entitlements, get his full severance entitlements, and it should be relatively straightforward in this situation. Now, not all situations are going to be the same, guys, so be sure to consider your particular industry, whether, of course, you're unionized or non-unionized. Unfortunately, in the unionized setting, the analysis is very, very different. You're effectively bound by what your union is going to do. But for those that are non-unionized, and in settings where the government has not mandated vaccination as a requirement of employment, you are going to have options, at least when it comes to severance and when it comes to getting the compensation that you deserve if you're going to be let go from your job based on this reason. So again, hot topic of the day, guys, mandatory vaccination policies. I'm sure lots of you have questions on the subject. I welcome all of them. I see a couple coming through already, which is excellent. We're going to get to those questions in a sec. Even if you guys are dealing with non-vaccine or COVID-19 related issues at work, this doesn't have to be entirely about mandatory vaccination policies. If you've been laid off from your job temporarily and your boss is saying, hey, have a seat at home, we're going to call you back to work when we've got work for you. That's a situation where you want to be getting some advice. Temporary layoffs are not necessarily legal. They're potentially permanent terminations of employment. If you've been temporarily laid off, you want to make sure you get advice, you speak to us and get good advice from an employment lawyer. If you're just dealing with a termination situation, maybe you've been let go completely unrelated to COVID. Maybe your office is being restructured and your job is been lost as a result of that. Before you sign any kind of severance documents, before you really do anything, you need to speak with an employment lawyer, get some advice. We are continuing to see lots and lots of severance packages be significantly less than what the employee is actually owed. Employers are making very, very low, very meager severance offers. You need to make sure if you've been let go that you have the compensation that you need in order to hold you over until you can find that next job. If you're being harassed at work, again, whether it's related to COVID or not, guys, if you're having difficulties with your boss at work, if your boss is treating you badly, maybe swearing at you, or maybe acting aggressively towards you, again, you need advice. You need to speak with an employment lawyer. You have options. You have rights as an employee in those kinds of situations. Ask us a question right now. I'll be happy to answer them for you. Or otherwise, again, contact us off air and we'd be able to guide you through that situation. All right. That's enough of me, guys, at least when it comes to the initial topic I wanted to talk about. Let's get to your questions. Again, that's what I'm here for. Ask away, guys. There's no time like the present to get your employment questions answered. All right. First in line, Emil asks, I work for a company that provides management services that does not have a vaccine mandate for a long-term care provider that does have a vaccine mandate. I'm unvaccinated. I'm not allowed into the LTC facility and placed on extended layoff. I'm not a member of a union. Do I have any recourse? Emil, excellent question. Difficult situation. I'm sorry to say. This is actually one of the trickier situations when it comes to these vaccination policies, when it's a third party that's imposing the rule. So in your case, if your employer is effectively contracted to a long-term care facility, you're absolutely right. Those long-term care facilities, and it's actually a government mandate. The provincial government is requiring long-term care homes to confirm that its employees are all vaccinated in order to work in the workplace. That is a rule that these companies have to follow. And so if your employer is now requiring its employees to be vaccinated as a result of that, listen, there's no other way to say it. It puts you in a very difficult spot where if that interrupts you doing your job because you're not allowed to attend on the premises of this long-term care home, your employer may have the right to let you go, and your severance entitlements may be impacted. They might be minimal as a result of that. So, Emil, you're in a situation that, again, is very, very difficult. You might lose your job over this issue. That is the practical reality of the situation, and severance is not necessarily a guarantee. That said, I don't want you to be despondent. There could be a way to work around this. There could be a number of ways in which you can resolve this situation. I imagine you might have had a chat with your employer about perhaps working remotely, so not necessarily having to attend on these premises. But certainly, if especially when it comes to long-term care homes, the rules are actually quite clear in requiring vaccination, and that might impact your ability to do your job, and that might impact your employability. Emil, again, these third-party situations, which is what I call them, where this other entity is requiring your employer to confirm that its employees are vaccinated, very, very nuanced, very complex. I would encourage you to contact us off air. Again, you can go to the website employmentlawyer.ca or email us at help@employmentlawyer.ca. It would be useful, Emil, to have a chat off air, get into the nitty gritty of exactly what's happening, what your employer is saying and isn't saying. And I'd like to give you some advice and some guidance moving forward. So contact us, Emil. It's going to be worth a conversation for sure. Alona asks, we have the right to refuse an unpaid leave of absence, correct? At that point, my employer has to pay severance, correct? Alona, the concept, generally speaking, is correct. An unpaid leave of absence is what we call a constructive dismissal. It's basically a termination in actions rather than words. Your employer, by refusing to allow you to work, is basically breaching the employment contract. Now, Ilona, before you go to your employer and tell them, and say this is a constructive dismissal, before you really say anything to your employer about an unpaid leave, make sure you're getting employment law advice first. Again, these situations are very circumstance and fact specific. It'll depend on your particular workplace, whether there's a government mandate in place, etc. So before you make any decisions, and this doesn't just apply to these mandatory vaccination policies, guys, any major issues that you're dealing with your employer, you want to make sure you get advice first. You don't want to pull the trigger, proverbially speaking, first, and then get advice after the fact. You might be doing more damage than good. So make sure you're getting advice before you claim constructive dismissal or ask for severance. Sometimes oftentimes actually, I would say, employees have to be very, very strategic when it comes to these situations. You don't necessarily just want to ask for severance. You may be giving up your hand, so to speak, in a situation like that. You want to play it, a little more strategically and tactfully. All right. Question from JC 2004. Your colleague mentioned that when a union is involved, to go through the union. Is that the same if your employer and your union are one and the same? Yes, JC, even if you, whether your union is one and the same as your employer or not, if you are a unionized employer, if you are bound by what's called a collective agreement, The terms of your employment are governed by that collective agreement, and your only legal representative is the union. You cannot hire an outside independent employment lawyer to represent yourself. Again, your union is the legal representative. So listen, I have seen some unions across the country in Canada file grievances over these vaccination policy issues. And we've also seen lots of unions side with the employers and go along with the vaccination policies. And unfortunately, your employment, your job, will depend on what your union's position is going to be. And again, ultimately, that might cost you your job if you refuse to be vaccinated. So if you are a unionized employee, speak with your union rep, voice your concerns. Again, some of them are filing grievances, some are not. And you'll ultimately have to decide what happens to your employment within that unionized context. An employment lawyer like myself, or any other employment lawyer for that matter, cannot help a unionized employee. All right, Wally John asks, we have to wait until January 1st, 2022 to take action against my employer. That was what your office told me in Toronto. I obviously don't know the context, Wally, but certainly if you spoke to one of my employment lawyers, then that may very well be the case. Perhaps you've been given notice of your termination on January 1st. Perhaps it falls in line with a temporary layoff situation. I don't know the context, but listen, our firm specializes in employment law. Our employment lawyers, that is all they do. It is the bread and butter of our work. It's what we specialize in. And so if you've received advice, Wally, from one of our employment lawyers, listen, it might not be what you want to hear, don't get me wrong, but it's going to be the correct advice. Justina asks, so to be clear, unpaid leave of absence initiated by an employer is qualified as termination and subject to severance pay. That's correct, Justina, but again, the context matters. Whether you are unionized or not matters. Whether there is a government mandate in place matters. Maybe even the kind of industry or workplace that you're in matters. So it is not a blanket proposition necessarily. As a concept it is, but again, the devil is always in the details. So before you make any decisions with respect to your particular situation, get advice. Make sure you speak with an employment lawyer. And chances are, again, if you're non-unionized and if you're not subject to a government mandate, then being put on an unpaid leave of absence is a constructive dismissal. It is a termination. You guys see the contact information rolling up on the screen. We're a little over halfway through today's segment, guys. Again, my name is Alex Lucifero. I'm an employment lawyer. I'm the managing partner of Samfiru Tumarkin LLP's Ottawa office. Again, we practice employment law in Ontario, British Columbia, and Alberta. If you are in any one of those provinces and are having issues at work, if you're dealing with a difficult situation at work, please contact us. Get some advice from our employment lawyers. We will be able to guide you and assist you. Whatever the issue is, whether you've been terminated or not, if you're struggling with an issue at work, if your boss is changing the terms of your employment, they're cutting your hours or decreasing your pay or doubling your workload, don't sit back. Don't just accept those changes and don't assume that what your employer is doing is legal. Make sure you get advice with respect to your particular situation. All right. Sorry, guys. The questions are coming in thick and fast. I'm going to try and answer all of them. But again, if I don't get to you, then please let me know. And again, contact us off air and we'd be happy to help. Ramez asks, in case of monthly salary pay and 8 years service, if the employer reduces hours and consequently the pay, could that be constructive dismissal? Of course, Ramez, it can. If you had a steady number of hours over the course of your employment, let's say you're working 40 hours a week, kind of full-time schedule, and all of a sudden your boss reduces that from 40 hours a week to 30 hours a week, well, that's a significant change. Obviously, it's a 25% reduction in your hours, 25% reduction in your pay. Yes, Ramez, that's going to be considered a constructive dismissal. So if you're in a situation like that, you want to get advice right away. If you have delayed getting advice and you've accepted the change, even implicitly, for example, if this happened 6 months ago, Ramez, well, then we might have a problem. You might have already even silently accepted that change by continuing to work. So as soon as there is a significant change in your employment, a reduction of hours, a reduction of pay, correspondingly, you want to make sure you act right away. Otherwise, you might be giving up your rights, even unknowingly. All right, Jeannie. Jeannie asks, what if your union is doing nothing? Jeannie, I hate to say it, but again, in the unionized setting, it's going to be up to your union to decide collectively what your position is on this issue of, again, we're talking mandatory vaccination policies here. And if they decide to go along with it, well, then you are stuck with that decision as a unionized employee. Unions are great for lots of things, job security, pay, etc. But there are some circumstances, this being one of them. Also, when it comes to severance, unionized employees get the short end of the stick. I wish I had better news for you, Jeannie, but again, as a unionized employee, that is the reality of the situation. Frank asks, my work has no employee contract. Is that good or bad? Well, Frank, if you are an employee, it's good. Having no contract of employment means that you are owed your full protections as an employee and your full severance entitlements if you're ever let go. From the employer's point of view, you do want to have contracts for all of your employees because you want to protect yourself as the employer. You want to limit your liability, limit your obligations, and that's what an employment contract does. It favors the employer and limits the liability that an employer has towards an employee. So, Frank, if you're without a contract, don't worry about it. You're actually very, very well protected, particularly when it comes to severance. Marissa asks, so if you're a non-unionized employee and suspended without pay, you can only get severance. Are you still out of a job at the end? If you are unionized, then it is whatever your union says, even if you don't agree. What about people paying for tests? Doesn't this create financial hardship for employees? Marissa, you are on the right track. I agree and appreciate the questions and comments. I mean, I guess to take one at a time, yes, unfortunately, in lots of these situations, the practical reality is these employees, even in a non-unionized setting, you're going to have to decide between getting vaccinated and keeping your job, or deciding not to get vaccinated, losing your job, but in which case you would still be owed severance. It's the practical reality of the situation, Marissa. We cannot force the employer to keep you employed. We can potentially engage in discussions, and maybe there's a resolution to be had there. To your point, for example, when it comes to testing, if an employer has offered kind of regular rapid testing as an alternative to requiring vaccination, that's actually a pretty reasonable resolution, provided, Marissa, to your point, that the employer is paying for the tests. I agree, it is a financial hardship for the employee. That's why the employer should be paying for regular tests. And I actually think that's a pretty darn good alternative to requiring vaccination in the workplace, is to do rapid testing. If I'm not mistaken, I think employers can actually obtain rapid tests for free from the federal government. They're actually giving them away to employers, and I think that's a pretty reasonable resolution. Melissa asks, I took childcare leave. It stated on the government website that it shouldn't affect my vacation time or seniority. I'm not sure about this, as it was bumped from 20 vacation days to 8 and second seniority to 4th. I was off approximately 4 months. Melissa, if you are talking about a unionized position, then you're going to have to look to the terms of your collective agreement, which might speak to the issues you're mentioning. If you're in the non-unionized setting, I agree, it shouldn't affect your vacation time at all. You should have the same vacation time you had before you took the childcare leave. And well, at least in the non-unionized setting, there's really no such thing as seniority in the unionized sense of the word in terms of being called for overtime or being called back from potentially temporary layoffs. And that's what makes me think that you might be in the unionized settings, in which case, listen, speak to your union rep. There might be an issue there. All right, guys, I love the questions. Keep them coming in. Unfortunately, I won't be able to get to all of them. I think we're running out of time today, but let's do a rapid fire last 5 minutes. I know I tend to get detailed with my answers, and hopefully that's appreciated. I'll try and do these a little more quickly so I can get to all of you. Vince rather asks, I deal with a bully daily at work. Person is out of control, yells, etc. We have a very weak HR. They are deemed irreplaceable by the corporate owners. Vince, if this is really rises to the level of harassment, and it sounds like it, and HR isn't doing anything, and the owner isn't doing anything, your next step is legal recourse. No employee should be putting up with harassment in the workplace. It is a legislated right under the Occupational Health and Safety Act, at least in Ontario, that employers have to protect employees from this kind of aggressivity. So Vince, if you're not getting help within the workplace from HR, you're going to have to reach out outside of the workplace to an employment lawyer. Again, send us an email, help@employmentlawyer.ca, or give us a call, and we'd be happy to help out. Lola asks, my job is harassing me in off the job, blackballed me. Now I'm forced to quit. I'm now dealing with anxiety and depression. Lola, same answer I just gave to Vince. Contact us, and we'd be happy to walk through the issue with you and give you the advice that you need. Nick asked, I put my resignation letter in due to stress. My employer called me and told me they changed schedule to only work 4 hours. Sounds like they want me to come back. Can they do that? Nick, certainly they can make you an offer to return back to work. You don't necessarily have to accept. That's something that is going to be negotiated between the employer and the employee if you're interested. If you're not interested and you've moved on, then that's absolutely fine. You don't have to accept. Keep in mind, if you've resigned as a result of something your employer has done, that may be a constructive dismissal. Again, I know it's a theme of the show, guys. You want to make sure you're getting advice before you simply move on, even in a situation where you've resigned. All right. Lisa asks, do you work in New York City? We don't, Lisa. We practice only in Canada and within Ontario, British Columbia, and Alberta. So unfortunately, we're not able to help our American friends. Let's see here. Chad asks, if I didn't get my W-2S from my work last year and they still haven't gave them to me, what should I do? The IRS isn't answering. Chad, sorry, I cannot assist. We are a Canadian employment law firm. You'll have to speak with an American employment lawyer and someone specifically within your state. Carrie asks, my employer put in a policy saying we have to be fully vaccinated by November 15th. If I go on sick leave due to stress, and sorry, I just lost the question. Oh no. Where is it here? Carrie, I got you back. Will this affect my severance if I'm entitled to it? Not necessarily, Carrie, although you can certainly go on a medical leave. It's an option. It's not necessarily the best option in that you're really just kind of parking the issue and putting it on the shelf. It's still going to be there when you're cleared back to return to work, whether that's in a week or 2 weeks or a month's time. You'll still have to deal with it, and the analysis will remain the same at that time. So it's, again, a question of whether there's a government mandate in place, what kind of industry you're in, whether you're unionized or not. So Carrie, might as well get that advice now, I would say. You might still want to go on the medical leave, but you probably still want the information and the advice sooner rather than later. So do reach out to us if you're worried about a termination. All right, let's keep it moving. Guys, can you explain the difference between federal mandates and the Ontario situation regarding hospital employees? Great question. Erwin asks, if you're in Ontario, Erwin, there's a direction from the provincial government, from the Ministry of Health, called Directive 6. It's not necessarily legislation. And interestingly, it provides for regular rapid testing or COVID testing in general as an alternative to mandatory vaccination. And so if you're a hospital employee in Ontario, then that is the regulation or the directive that applies to you. It doesn't matter what the federal government is saying. Keep in mind, guys, the federal government can only impose any kind of legislation or mandates with respect to federally regulated employers. And those are very few and far between. Banks, telecommunication companies, transportation companies, that operate across provinces and, of course, internationally, and a couple of other industries, but there are very few. Hospitals or healthcare isn't one of them. So, Erwin, your employment is provincially regulated if you're a hospital employee. All right. I think that does it for today, guys. I'm sorry I didn't get to all of your questions, but hopefully I helped as many of you as possible. Thank you very much for joining us. We do these regularly throughout the week. So if I didn't get to your question, you will have another opportunity next time. I believe we're doing another show tomorrow and another Friday. Otherwise, give us a call or contact us off air. Again, help@employmentlawyer.ca is the email address. Employmentlawyer.ca is the website. I wish you all a great day and a great rest of the week, and we will catch you again next time. Take care.